Let's talk about the ultimate modern relationship anxiety. Picture this. You've worked incredibly hard, saved up every penny, and bought a home way before you ever met your partner. Or maybe you received a really meaningful inheritance from a loved one. Years go by, you fall in love, move in together, and out of a sense of unity or maybe just practical estate planning, you add your partner's name to the title of that property. And then the relationship ends. The burning question that literally keeps people up at night is, if I put my partner on the title of the home I owned before we even met, am I going to lose half of it in the split?
Well, let me tell you, that is a completely valid panic. Because for years, right here in British Columbia, the terrifying reality was that a seemingly innocent transfer of title could literally cost you everything you brought into the relationship. We are talking about millions of dollars in wealth just vanishing, simply because someone's name was added to a piece of paper. So to understand how we got into this massive mess, and more importantly, how the law has recently swooped in to fix it, we need to dive into exactly how property division works when love goes wrong. To see just how dangerous this trap really was, we don't even have to look at hypotheticals. We can look at a shocking landmark 2016 BC Court of Appeal case known as VJF v. SKW. In this case, a husband received a massive $2 million gift from a third party. Now, normally, a gift like that is your own separate property, right? Keep your hands off. But the husband took that $2 million, bought real estate, and made a totally catastrophic legal mistake with it.
You might be wondering, wait, what did he do? Why on earth would he put a $2 million asset entirely in his wife's name? Was it some grand romantic gesture? Nope, not at all. He was a businessman, and he did it strictly for creditor protection. He basically wanted to shield that massive asset from any potential future business creditors. It's a super common financial strategy, you know? But man, when the couple separated, that strategy backfired in spectacular fashion. Here's exactly where the trap snapped shut. The court applied this old common law concept called the presumption of advancement. Basically, historically speaking, the law said that if a husband transfers property to his wife, we're just going to presume he meant it as an absolute no-strings-attached gift to her. And because the court considered this $2 million transfer a true gift, it completely lost its status as his protected, separate property. Poof, gone. In an instant, that $2 million turned into divisible family property. Just because he tried to protect his assets from creditors, he ended up losing half of it in the divorce. Crazy, right? Now you're probably asking yourself, is this the rule everywhere? Like, if I live in Toronto, am I falling into this exact same trap? Well, that's where geography completely changes your legal reality. In Ontario, the Family Law Act handles this totally differently. Over there, Section 14 essentially presumes a resulting trust between spouses, treating it almost like they aren't married, though they do have specific exceptions for property held as joint tenants. But in BC, before some very recent legal changes, placing an asset in joint names or your spouse's name was essentially a trapdoor that completely stripped away your sole ownership rights. To truly grasp the massive public outrage over that $2 million case, you kind of have to understand the baseline rules in BC. The 2013 Family Law Act was originally meant to be a super simple, predictable, keep what is yours system. It created a category called excluded property. This covered things like inheritances or the house you owned before the relationship even began. The rule was supposed to be that if you separate, you only share the increase in value of that property, but you get to keep the base asset. It was supposed to fit perfectly with our natural, everyday expectations of fairness. But wait, you might say, what if I've already mingled my assets? Because let's face it, living in BC, the housing market is absolutely astronomical. Most couples literally have to pull their resources, remortgage, and put homes in joint names just to survive the market. Registering a home in both names reflects the unity of a couple, and it's just a smart, practical tool for estate planning. So it felt like doing what was completely natural and necessary meant couples were accidentally throwing away their excluded property protections. Exactly! The law just wasn't working the way people actually live their lives. It caused a solid decade of immense joint title anxiety. But hey, that brings us to the superhero moment of this explainer. After years of the old Family Relations Act model, and then a decade of the 2013 Family Law Act causing all this panic, the BC legislature finally stepped in. They passed sweeping, absolutely critical amendments to the Family Law Act that officially took effect on May 11th, 2023. Here's the big game changer. The government introduced a new Section 85(3). It explicitly states that if property falls into the excluded category, like your pre-owned home or your inheritance, quote, the exclusion applies despite any transfer of legal or beneficial ownership of the property from a spouse to the other spouse.
Think about the weight of that sentence for a second. It means that transferring your excluded property into joint names or even solely into your spouse's name no longer magically strips it of its protected, excluded status.
And the best part? They didn't stop there. To make absolutely sure the ghost of that $2 million case was dead and buried, the new Section 81.1 officially abolished the presumption of advancement between spouses for questions regarding property ownership. No more ancient common law assumptions that you're just gifting away your entire life savings just because you added your partner to the deed. This effectively closed that terrifying loophole for any court proceedings or agreements started after that May 11, 2023 date. The law finally aligns with common sense.
Okay, I don't know about you, but my blood pressure is finally dropping. We can finally add a spouse to the title without instantly forfeiting our life's work. But hold on just a second. Are we totally 100% safe now? Is this new legal protection an absolute impenetrable shield? Can you really keep a house entirely to yourself after decades of marriage just because your name was on the deed first? Or is there a catch? Well, here is your reality check. Because this is the law we're talking about, there is always an exception to balance the scales. Under Section 96 of the Family Law Act, a judge still holds a very powerful trump card. Even with all these awesome new protections, a judge can still order the division of your precious excluded property if keeping it strictly separate would be significantly unfair. Notice the specific phrasing there. It doesn't just say unfair, because let's be real, all breakups feel a little unfair. It has to meet a really high threshold of being significantly unfair. So how does a judge decide that? The law gives them some strict criteria for deciding what actually crosses that line. First, they look at the duration of the relationship. A quick 2-year relationship is very, very different from a 30-year partnership where your lives are deeply intertwined. Second, and this is absolutely crucial, they look at direct contributions. Did the non-owning spouse spend 20 years physically renovating that pre-owned house? Did they manage it, maintain it, and directly cause its value to absolutely skyrocket? If someone literally poured their sweat and money into a home, telling them they get nothing just because of a pre-existing title could very well be deemed significantly unfair.
Which brings us to a really profound collision between strict property law and human reality. The 2023 amendments give British Columbians an incredible, much-needed layer of protection. They allow you to pool your assets and plan your estate together without that instant panic of losing your pre-relationship wealth. But it still asks us to weigh cold, hard titles against the shared life and sweat equity you've built together. So I'll leave you with this. When does keeping strictly what's yours become significantly unfair to the person you loved? It's a fascinating ambiguity and something really worth pondering. Thank you so much for joining us for this explainer. Keep asking the big questions, and we'll catch you next time.